Good morning, everybody. Welcome to this My HR Toolkit webinar. My name is Simon. Some of you will know me as the Sales and Support Team Leader for My HR Toolkit. And today, as a continuation of our series of webinars that we've been doing throughout the pandemic, we are going to be talking about how to handle employee grievances. Shortly, I'll hand over to our speaker today, Catherine Wilson, who is the Head of Employment for Keebles LLP. Now, if you have attended some of our webinars previously, you'll be familiar with how our webinars work, and it's great to have you guys back with us. If you are new to our webinars, then it's fantastic to have you with us as well. We have a fairly simple format. Once we hand over to Catherine, we'll have about half an hour where Catherine will present to you. Throughout that time, if you'd like to use the chat, please feel free to do so if you want to send us any messages, and we're quite happy for you to do that. We will have time after the talk to go through any questions. If you do have specific questions about today's webinar topic, then just add them into the Q&A, which is in the menu bar at the bottom of your screen, and we will answer any of those questions that we can after we've heard Catherine's talk. Now, I should point out as well today that today's session is offering general and not legal advice, and is based on the information that is available as of today. And after the webinar, we will send you a follow-up email, and we will show you where the recording is available. We are recording these webinars, and if you go to myhrtoolkit.com/webinars, you'll be able to catch up any of the previous topical webinars that we've been doing. And there are also training webinars, specific training webinars for elements of the My HR Toolkit system for current users. So I'm going to hand it over to Catherine now to talk about employee grievances. Good morning, Catherine. Thank you for joining us.
I think I'm now unmuted. Is that right?
You are unmuted now, yes.
Excellent.
Yes.
Well, it's great to be here and to talk about how employers can hopefully successfully handle grievances. This is going to be a slightly different type of talk. I think a year on, we're all pretty anti-PowerPoint. Certainly, I think we're all pretty zoomed and teamed out. So we're going to try today to make this more interactive and not use the dreaded PowerPoint slides, which we hope is going to make this more accessible and certainly more enjoyable. Simon's already talked about the question and answers, and I would really encourage you to use the session to ask any questions that you have about grievances. I think it's one of those topics that crops up a lot. And for the reasons that I'm going to explain later in the talk, is something that I think we're going to see even more importantly in the future. So yes, no more incomprehensible graphs, no more PowerPoint. I've done several talks over my career about grievances. And for many years, we would always start by saying to the audience, so I would ask you virtually to do this wherever you're sitting, how many of you had actually been involved in a grievance? And generally speaking, there would be very, very few people, if anybody. There are, in fact, no official figures for how many grievances are issued each year. But anecdotally, we know that the pandemic, lockdown, and the challenging times in which we're all living have certainly seen a rise in employee dissatisfaction, which in turn has seen a substantial rise in the number of grievances that certainly our clients are dealing with, and we expect in due course a rise in claims. I think there are a number of opening remarks to make about grievances. The first thing is that there is no minimum qualifying period. So an individual can start work on a Monday and on a Tuesday issue a grievance. Clearly their options and remedies are different, but it is important to know that the grievance is what I would call a day one right. I think the other thing to say is that for many grievances, there's a sort of inherent vagueness. And as a consequence, often the nature of the grievances can be misunderstood, and indeed sometimes missed altogether by employers. And then a final point, and I'm not sure because I don't see the guest list for this event, I don't know how many of you are line managers as opposed to HR colleagues on this call. I think it is absolutely critical to train managers in how to recognise and deal with those grievance situations. So if this talk goes any way towards giving some background on that, then it will have achieved one of its purposes. So where do we start? Well, I think the first question many of you may be thinking about is, what is a grievance? She's just told us that most people can't recognise it and don't know how to deal with it. So what is it? The key point is there are various definitions. Put at its simplest, a grievance is a complaint by an employee against their employer. And if we look at the ACAS Code of Practice, which we're going to refer to quite a lot in this talk, and I'm sure has been referred to in previous talks, it defines the type of complaint very widely. It talks about any complaint, concern, or problem. I think in lead speak, we would say how long is a piece of string. It could be very, very wide ranging. And most importantly, it's not limited to simple breaches of the employment contractual terms, be they implied or explicit terms. Again, another problem is that because the scope is so wide, then it can overlap with different types of concerns and complaints and sometimes policies. And where we come across some of those overlap areas, I'm going to touch on those in some detail. So we've identified what a grievance is. What is the appropriate procedure? Well, here again, it is quite interesting because there are a lot of very useful policies which we as your employment lawyers are always encouraging you to have. So performance management, sickness management, and they are very useful, but they are strictly not compulsory. In contrast, grievance procedures are compulsory, and employers as a matter of law have to explain to their employees their organisational approach to those grievances. Again, there's no obligation to provide a formal contract of employment, but there is a legal obligation to provide what we call the Section 1 Statement of Particulars to employees, and since April 2020, workers. And crucially in this area, when we're looking at grievances, the Section 1 statement must contain a note on grievances under Section 3, subsection 1 of the Employment Rights Act 1996. And I'm going to read out what this section says, because before we look at grievances and how we handle them, we need to know where this all started. So, a person to whom the worker can apply for the purpose of seeking redress of any grievance relating to his or her employment and the manner in which any such application should be made, and where there are further steps to be taken in any such application, explaining those steps or referring to a document which is reasonably accessible to the worker and which explains them. So again, it obviously anticipates that there is a process. The written process doesn't need to be in the statement of particulars, but it needs to be referable in that statement. Key important exception, and I'm glad to say beyond the scope of this talk, we are not touching on any complaints in relation to health and safety. They have a different statutory framework, and as I say, are beyond what we're going to talk about today. But that's the only exception. Everything else is really covered. So we know that there has to be a procedure, and we know what a grievance is. So what is the right grievance procedure? Well, generally speaking, most employers have a comparatively short formal grievance procedure in a handbook or an intranet. It usually follows a very similar format and has what we call the 3 stages. So it has the informal stage, it has a formal stage, and it has an appeal. This is not, however, mandated, and if you wanted, then you could clearly look at doing something more complicated with provisions for independent investigators and indeed mediations. The scope, though, is very much up to the employer. So, first question, do you know where your own grievance procedure is found? When was the last time you looked at it? Is it still fit for purpose? I think it's also important to distinguish between what we call an individual grievance, which is any complaint, concern or problem, and a collective grievance. Those of you who are operating in a more unionised environment, let's say, may find that from time to time a group of employees band together with a similar complaint, usually about contracts and indeed the effectively working conditions. Those type of collective grievances don't normally fall part of this individual grievance process. Again, they have a separate process, which is generally under a collective grievance and or a disputes resolution process. So again, it's all about recognising what type of grievance you're dealing with and which policy applies. I think the key point to also recognise is that the main purpose of raising a grievance at work is to try and resolve problems. I'm going to repeat that again. The main purpose is to try and resolve problems. Often, and many of you will, I think, identify with this, when we're dealing with grievances, it's quite clear that often they take on that characteristic of a disciplinary. So it's very important to keep that primary motivation, if you like, front and centre. The objective is to try and resolve complaints informally, and in the first instance by speaking to the line manager. Now, sometimes this is often, in fact, not always possible. Sometimes this informal conversational resolution doesn't work and the employee feels the need to formalise. So if we go back to my 3-stage process, that would be stage 2. Other employees move straight away to the formal stage 2. Often when the complaint is particularly serious, often indeed when the complaint is about the actual manager themselves, and I touch on this later on in the session. Again, you will appreciate that the informal nature of stage 1 is perhaps one of the reasons why it can be so difficult to identify whether or not there is in fact a grievance. So often the employer may not even recognise that the grievance has been raised. Certainly the line manager may not see it as a grievance. At what point does a mere moan become a grievance? I think it's therefore very important, and perhaps something we can talk about in the Q&As, about recognising what is a grievance, but also what steps you take to monitor and indeed record centrally even informal complaints or grievances, and also the action which has been taken. I think one of the reasons in my earlier talks nobody knew they had a grievance was often those early stage 1 grievances had effectively been overlooked or swept under the carpet. And I think that that can be very problematic, particularly when we talk later on about the increasing concerns I think many employers are facing with what we call the serial griever. So I get the complaint, what do I do? Well, when the manager receives the complaint of the grievance, I think it's also very important, with advice, to decide whether it is in fact suitable for the grievance procedure or whether or not another policy is more appropriate. So often the clients will have a range of different policies. So for example, whistleblowing, diversity, equal opportunities, bullying, and of course redundancy policies. So again, it may be that the complaint should be dealt with under one of these other policies rather than the grievance. Again, I've already asked, really, anecdotally, how many times have you reviewed your grievance policy recently? Key issue often in practice is how do all these different policies and frameworks fit together? Because often they're written at different times and actually they don't fit together terribly well. And that does add, I think, to some of the confusion and complexity about handling grievances. Again, specific issues about, in the current climate, about the use of the grievance procedure in relation to redundancies. And this is something I'm going to discuss later. But certainly an appeal process for a redundancy as a general principle is distinct from the stage 3 or the appeal in relation to the grievance. So I said a few moments ago that unfortunately many of employee grievances are against their manager, which is why often we find ourselves going straight away into stage 2. Most grievance procedures, however, are written in a way that envisages that employees should submit any grievance to their line manager. There should always be a provision, however, for that process to be side-tracked. So if the person they're complaining about is their line manager, then they can submit it to another manager, maybe their manager's manager, or indeed as a backstop, the HR department, if there is one. I think there are a number of key issues to think about when we're determining who should deal with the grievance, who is best to investigate, how, if the thing progresses from informal to formal to appeal, who will deal with those various stages. We often find clients run out of people, in fact, and I've got some ideas about how we can deal with that in due course. And I think it's also important to realise that the line manager may be inappropriate. Often it seems to be a given that it should be the line manager. I would ask you to step back and take a slightly different view about that. Here, the key thing as well is timescales. The ACAS code talks about grievances being resolved in a reasonable time period. Most policies I see envisage a time period of 5 working days. That seems to me to be a real hostage to fortune. 5 working days, even pre-pandemic, was super quick. I'll give you an example, a case in which I'm dealing at the moment. The gentleman lodged his grievance in early January, and we have still not got to the start of the investigationary period now, coming up for 3 months later. So things can take a lot longer. So to try and give yourself that flexibility is important, but also it is critical to realise that these grievances do have to be dealt with in a timely manner. You have to be able to justify any delays. If there is an undue delay, that would be seen as a breach of trust and confidence and could potentially be grounds for constructive dismissal. So I think there is a careful balance, but I think as an action point from today's talk, I think reviewing what your own policy says and how it works, I think would be strongly recommended. So I think the next point is the right to be accompanied. And I think it's a mark of how important lawmakers view the grievance procedure, that this is one of only 2 areas of employment legislation where there is a legal right to be accompanied by a trade union representative or a work colleague. The other, of course, being the disciplinary procedure. I think this is particularly striking, given that the right to be accompanied in relation to redundancy consultation is advisory, although clearly good practice according to the ACAS guidance. For completeness, generally no right to be accompanied by a lawyer. I'm not desperately keen on family members either. Everybody seems to have a relative who's a lawyer, or a godmother who's an employment lawyer, in fact. But the fact is that is going further than the rights provides. It may, of course, be a reasonable adjustment to vary the rules on the nature of the accompanying colleague, or indeed to allow additional support. So, for example, a reasonable adjustment when dealing with an employee with a mental health disability who has a grievance would be to allow a mental health support worker or an advocate, or similarly a young adult with learning difficulties. You might very well allow a family member to accompany them as part of the grievance process. I think this part of the duty to make reasonable adjustments applies in the context of grievances as elsewhere. The stop response, the policy says no, really does not fit the bill and does not meet that obligation. So we've talked about the grievance process and we've talked about how it should operate. I'm now going to touch on some of the really common queries that we have on a regular basis in terms of grievances. I think I should declare an interest at the beginning that, not surprisingly, being an employment lawyer, we only see the really nasty grievances. And I'm sure there are hundreds of thousands of grievances where no legal advice is required and these issues don't crop up. So do bear with me and forgive me if you think I'm sort of over-egging the pudding a bit. First question is, can an employee record the grievance meeting? Employees should not record the meeting without employer's consent, and generally most employers are unlikely to agree to allow the recording. I'm going to talk later on about some of the slight differences that we've seen during the pandemic and socially distanced meeting, but generally speaking, I think it is the norm not to allow recording. The employee should be encouraged to ensure that their companion takes a detailed minute of the meeting. And it's acceptable, in my view, for the employer to remind the employee about this option at the beginning of the meeting, and for the fact that they were reminded to be raised in the actual notes, because certainly as the employer, you too need to have somebody else who is going to take a good note. Never do a meeting like this on your own. As an employer, you should take the view as to whether you're going to volunteer a copy of the notes to the employee. I would have some hesitation about providing a draft and asking for comments. It's notoriously difficult to agree the notes. We call it the battle of the notes. So I think it's absolutely fine to provide a copy of the notes. Query on the comments. I have seen some clients increasingly having dual sets of notes. That seems incredibly fair and reasonable to me. I can see in tribunal terms, though, it may be a bit problematic, because I'm not sure that the tribunal judge is going to be that keen on deciphering the difference between the employee and the employer notes, and there's going to be quite a lot of pressure to agree a copy. So I think the old style approach of the employer's notes are those which are relied on, I think is possibly the practical way to go. We are seeing an increasing incidence of COVID recording. Let's face it, on any basic phone, it's incredibly easy to do that. We see lots of instances where people leave their jacket on the chair mid-adjournment in disciplinaries and grievances with the phone recording, and or they leave the phone in a bag or a rucksack. I think it's really important that you are alive to that. I think it's incredibly important at the beginning of any session, let's say a grievance, that you make it clear and you ask the employee if they're recording. If the employee then goes on to record, it does go to their credibility. I think there's only a bit of a public health warning here. The fact that it's a covert recording does not in itself mean that it cannot be used. As the employer, we can argue that it's inadmissible, but the tribunal will then take a view as to whether or not the evidence should be allowed or not. And I think the key point here is it isn't absolute, and that the recording may be admissible if the evidence is relevant in terms of an important point and actually goes to whether or not the employer has lied or been less than honest. So I think it would be lovely to say, if you don't have your permission, they can't use it. Unfortunately, I think that's giving you scant comfort. So we need to take really clear steps to ensure that everybody is aware of the expectations, and also to try and avoid that covert recording wherever possible. The other thing we're also seeing now, and it comes up again in relation to the pandemic, is where grievances are dealt with remotely and the individual is at home, we're seeing the increasing number of unidentified, anonymous, but nevertheless present individuals, usually wives and children, who also are taking a note. So I think this is a particularly tricky area, and something which I hope will abate as we move away from lockdown, but it may be one of those features that is simply going to continue going forward. The next issue is dealing with the reluctant or absent witness. A lot of the grievances that we deal with are between employer or line manager and employee, and there are no witnesses. Sometimes, however, there are witnesses, particularly to complaints about the way in which an individual is being managed, spoken to, allegedly bullied. And unfortunately, but perhaps understandably, some witnesses do not want to participate. They see themselves rather like turkeys voting for Christmas. First stage is to understand the reasons for that reluctance and whether there's a way to resolve the issues by talking through the process and explaining the relevance of their evidence as part of the investigation, and also providing some reassurance that they are not, as they say, turkeys voting for Christmas. If the witness continues to refuse to participate, then the employer has to consider on whether or not to continue with the investigation without their evidence. Alternatively, are they comfortable going ahead with the grievance and relying on the evidence, but making sure that these statements are anonymous? Now, anonymous statements have been a long-standing problem going right the way back to the 90s. But according to the ACAS Code of Practice, and I told you we'd be coming back to that, and indeed tribunal case law, can be used, but only in exceptional circumstances. The employer needs to balance the fairness issues between the parties and the risk, for example, of bias or some sort of malevolent motivation. I think there's a particular issue where the grievance statements might form the basis of a future disciplinary matter. And as I said, grievances to start off with, first and foremost, are about resolution. However, they're not wholly divorced from the disciplinary process. And I think particularly if you look at an anonymous statement, you would need to take that with a great deal of care. Generally, though, I would say the use of anonymous statements in a grievance rather than a disciplinary process is easier to justify. So we've done the informal stage. We've now done the formal stage. The individual is still not happy. Well, is there a right of appeal against a grievance? Procedures generally include at least a stage 3 or a right of appeal. So the employer should inform the employee of their right to do this in the outcome letter at stage 2. At stage 2, there's normally a deadline for appealing, plus it's worthwhile asking for the grounds of those appeals, although there's no strict obligation upon the employee to provide these. Another way of achieving greater clarity is to specifically ask the employee for their preferred outcome. The nature of the appeal, again, I think is very much up to yourselves. It can be a paper review, it can be a formal hearing. Again, I think we've seen a trend towards more stage hearings rather than paper reviews, but this is something which I could imagine slipping backwards again as we come particularly out of lockdown. Another topic which comes up a lot is, can an employee raise a grievance if they are being disciplined? If you forgive the cynicism, it would be fair to say that in most particularly performance related dismissal processes at some stage, the employee tends to raise a grievance. Employer can put the disciplinary process on hold while the grievance is dealt with, but it does depend upon the nature of the grievance. So if the issues are wholly interlinked, so for example, the employee disputes the fact that she's been disciplined or has a complaint about how the disciplinary process is being handled, then that grievance can form part of the disciplinary process rather than being dealt with separately, and a delay would seem inappropriate. If it's unrelated, however, the grievance can happen in parallel. No reason to hold it up, as it were. I think those instances which are complex are where we're dealing with a situation which has what I would call history. So if, for example, the grievance is that the disciplinary manager is bullying the employee or has a previous history of bullying, then I think you've got to give active consideration to suspending the disciplinary whilst the grievance is completed. And ideally, a separate manager deals with the grievance and the disciplinary. Although I do appreciate that this isn't always possible, particularly in a SME space. So again, I think one of the options which I see increasingly used is practical consideration to a third party involvement. So external HR consultant, sometimes non-exec directors, some trustees, depending upon the environment and the organisation. I think facilitated conversations between the parties have also had some success in my experience and would sit outside of the formal grievance, but are clearly linked within it. Next question, I think comes up a lot. Can the employee use the grievance procedure to appeal the redundancy? Generally, no, because as I've said before, the redundancy policy will include an appeal. However, may be appropriate to pause the redundancy process in limited circumstances. For example, if the grievance relates to the decision to declare the redundancies per se, and therefore their selection is because they're in a pool of one, and they allege that that's because of the early bullying and victimisation, then I think there's a strong argument that the redundancy process should be paused pending the resolution of that grievance, because clearly if the outcome of the grievance is that they were bullied and victimised and that this was the motivation for declaring their post redundant, that will be highly relevant. Next session I wanted to talk to is about how we handle grievances during the pandemic. And I'm sure many of you who read blogs and things on LinkedIn will note there's been a lot of commentary about this. Again, start point has to be the updated ACAS Code of Practice, and specifically the guidance which they issued back in August 2020. The key point about this is that it confirmed that the normal Code of Practice on disciplinary and grievance procedures would still apply, notwithstanding lockdown and social distancing. But there was an acknowledgement that things possibly would have to change, and that an employer needed to consider how to proceed in a fair and reasonable fashion, given the circumstances of the pandemic. It was also made pretty clear, if there was any doubt, that a furloughed employee, for example, could raise a grievance, and similarly that a furloughed trade union representative and or another employee would be permitted to actually act as a representative in any process. So I think there are some common threads, though, that come out of our experience in the past year with dealing with grievances during the pandemic. And whilst each case is on a case-by-case basis, hopefully this will be helpful. The first point, which was quite popular back in the spring last year, was should we suspend the grievance pending the release from lockdown or go ahead? I think we all know now that it would have been very problematic if clients had suspended those grievances, or indeed disciplinaries. They would have been suspended for an awfully long time. And in fact, that was a piece of advice which I think was honoured more in the breach than the exceptions. And I'm not aware of masses of claims being stayed or grievances put on hold. I think there are issues about whether or not meetings go ahead in person or remotely. I think you have to consider the social distancing rules. I think you also have to consider the particular circumstances of the individual. So is the person bringing a grievance particularly vulnerable? Are they so-called shielding? Are they living with somebody who's shielding? Would the socially distanced meeting help, whether that's remote or whether that's in a socially distanced manner within the workplace? I think, again, We could talk about how they can be fairly accompanied. How is that actually going to work? It seems to me that the relaxation of the rule at 6 next week will allay some fears, as will the end of shielding come the 1st of April. So I think that will all become more straightforward, but it has been a bit problematic to date. I think if the workplace is open and you would prefer to have a face-to-face, then obviously you need to ensure that you can demonstrate within your risk assessments that compliance with health and safety, and that it is indeed a COVID secure workplace. I think the other issue which has cropped up, and those of you who've had the misfortune to do remote hearings in the tribunal may be able to empathise with this, access to video technology for long meetings, be that the court video platform or be that to Zoom or Teams, can be difficult. Not only is there a need for access to that technology, but there also needs to be a secure connection. Particular issues about access to written evidence. Some people are more IT orientated than others, can manage with screen sharing, but often that's not practical. So there needs to be a provision of hard copies and witness statements. I think as well, any specific disability issues need to be considered in the context of reasonable adjustments and the pandemic. And finally, we talked about recording, and obviously our webinar today is going to be recorded. We similarly talked about the need for the consent of the parties to do this. I think we will see more recording, but again, must comply with the data protection rules. How long are these recordings to be kept and by whom? Because there is this overriding need to protect and secure copies of the recording. But who knows, it may beat the battle of the notes, and of course may give a much more accurate account of exactly what happened. Next thing I wanted to talk about is the serial grievance raisers. These are the individuals who crop up from time to time, who raise grievances in an unreasonable or excessively persistent manner. And I've already said that probably a disproportionate number of these come across our desk as employment lawyers. And if you'll forgive the commercial break, I think if you'll find yourself dealing with a serial grievance raiser, this is definitely the point at which legal advice can be really helpful. So what are my tips for dealing with serial grievances? Well, the starting point is to treat it as genuine. So refer back to the policy. However, where it's clear there's been no success using the internal procedures, then this might be one of those instances where you could use alternative procedures. So the ACAS Code of Practice on grievances recommends considering a fourth stage, namely external mediation by a third party, with the aim of easing tensions and aiding resolution, which would also have the knock-on effect of minimising the risk of serial grievances. I would see this as very much the exception, so I would be unenthusiastic about adding to every grievance policy a stage 4 mediation. However, I do think it is something which should be considered, and in practice can be worth the investment in time and effort to obtain a smoother resolution. I think another practical tip is to provide a serial griever with a single point of contact for all inquiries to ensure nothing is overlooked. I think this has a number of benefits. I've already said that it can be quite hard to recognise these grievances. When I look at serial grievance claims, it's quite obvious that the first grievances generally were either overlooked, not appreciated, not treated seriously. So having that professionalism right at the beginning, I think would really help. And similarly, I think it helps persuade the employee that their complaint is being well founded. As I said at the start, and I've repeated, the aim of the grievance is resolution. And it seems to me that if there is that element of trust between the single point of contact and the person with the grievance, you are much more likely to receive that. However, there are definitely some grievances where there is a strong feeling that the complaint is not genuine. And in those instances, having given careful consideration to the facts, the history, and I would say strong legal advice, the employer needs to consider whether or not that complaint is indeed unfounded and the basis for the belief. Is the serial grievance dishonest or malicious in motivation, or is it simply a mistake or a misunderstanding? If it's a mistake or a misunderstanding, it can be quite irritating and time consuming, but an informal discussion may very well resolve the situation. If, however, after due inquiry, there is a view that in fact it is dishonest or malicious, then it may be appropriate for the employer to refuse to hear the grievance and/or in extreme circumstances take disciplinary action. I think the common example of this is where an employee persistently raises grievances of a very similar nature on a particular colleague, and it looks to be a malicious motivation. And again, we see that those claims often result not only in constructive dismissal, but in what we call the breakdown of trust and confidence, which in its turn can be some of the substantial reason justifying dismissal. So, in summary, compliance with the ECAS code doesn't invariably mean that the employer is obliged to respond in detail or even exceptionally at all to numerous repetitive complaints. I regularly see clients who might receive 5 or 6 email complaints per day. The technological equivalent, could say, of the green capital letter bold letters that were passed through the system. So may be appropriate to sift through those complaints, and often in one grievance there may be reasonable and unreasonable elements. I think one of the problems sometimes is that in frustration the employer can give up and can disregard the one reasonable complaint amid the myriad of the 99 others that are completely malicious and meaningless. If we're doing that sift though, we need to explain to the grievee in a calm and measured but not too lengthy way why some are being considered and some are not, and that the fact that they're all in one piece of correspondence or chain of correspondence doesn't alter their relevance. It can also be a bit of a judgment call as to whether the grievances are repetitive and have already been dealt with previously, but I wouldn't shy away from making that comment if you're satisfied that that is in fact the case. I think the key point is taking no action, no matter how frustrating, is not an option. So you've all been sitting here now thinking, why do we do with these grievances? Well, I think the key point is, with the grievance process, in legal terms, there is what we call double jeopardy. If the employee doesn't raise the grievance, then they lose the right to dispute the way that they've been treated. If they fail to lodge an appeal, then they lose the opportunity to state why they do not agree with the outcome. Even if their subsequent tribunal claim is successful, then they're at risk of having their future compensation reduced by up to 25%. Equally, if the employer fails to deal with the grievance, then obviously there's the risk of constructive dismissal as a breach of the implied term of trust and confidence, but also compensation can be increased or uplifted by 25% if the employee is successful at a subsequent tribunal claim. So we know that handling grievances is important for lots of very positive reasons, workplace relations, because that is our obligation as employers, but there's also a financial stick as well. And finally, employees are protected from being treated unfavourably for raising a grievance. So, for example, they're protected against unfair dismissal, discipline, or indeed selection for redundancy. This is what we know as, in layman's speak, as victimisation. This is a complex legal area which is beyond this scope of this talk, but it's key to note that this protection is unlimited in time. So the fact that an individual pursues a grievance, the grievance appears to have been resolved, and they are then subject to, let's say, a redundancy exercise some years later, they can still refer back to that grievance. Although clearly, the greater the distance between the grievance in time and the alleged detriment, the much harder it is to prove the link in practice. So those are my comments about grievances. I'm now very happy to hand back over to Simon and see if we've got any questions.
Fantastic. Thank you very much, Catherine. I think it can be a minefield, can't it? Employee grievances. And I think it can be terrifying for employees, can't it? Especially if the grievance that they're going to raise is against their direct line manager or another senior member of a company. What would you say to someone who might be facing that situation?
Well, I think the first thing, and it was the last thing I said, but employees are protected. You are protected, about, you can't be subjected to a detriment because you've sought to enforce one of your statutory rights. And one of those statutory rights is to bring a grievance. And the tribunals take victimisation allegations very, very seriously. And from my experience, in fact, very few employers, I can't think of any really, where they have actually victimised people because they have brought grievances. I think there are two types, though, that I would draw your attention to. Some people would bring a grievance. It's very much a last resort. They'll probably only ever do one in their entire working life. are serial grievers, I think do make it very difficult for themselves to remain in that employment. So I think they're in a slightly different category, but 99.9% of people, if they bring a grievance, it's a one-off. There are generally no adverse consequences at all.
Okay, now we do have a number of questions. We'll go through some of these and we'll see what we've got. So we've been asked, what would you advise if an employee that sends you an email saying a couple of their team members that they manage are working against them in one-to-ones and team meetings? They have asked if they should raise a grievance and how they should do it.
I personally would see that as more of a management process rather than a grievance process. I think the fact that the individuals appear, as you say, to be working against each other, then that should be discussed, whether it's a team chat, whether or not another manager becomes involved. I'm not, by nature, my experience of managers bringing grievances against their direct reports is very unhappy. So I think it is a management process rather than a grievance or a complaint process.
Okay, we've got the topic of recording grievance meetings has popped up. So we've got a few questions about this. So we've got an employee who has recorded the person that they have a grievance with without the consent of that person. The company are not allowing that recording, and then the employee is saying that that is discrimination.
Well, that's a lot of questions in that, isn't there? I suppose the first question is whether the employer is right not to allow the recording, even though it is a covert recording. If you go back to what I said in the talk, the tribunals will even allow covert recordings without consent. So I think an employer would need to be able to justify why they're not looking at that recording. I don't really understand the discriminatory element in the sense that presumably it's an across the board policy. So it's not just that they're not prepared to allow that particular individual to behave in that way because of their race or their gender or some other protected characteristic. So it can be, I think it's about fairness. I don't think that's necessarily the same as discrimination.
Okay, there's a few questions about recording.
That's all right, go ahead.
So we've been asked, why is it not best practice to record the meetings?
There are some clients who do record meetings. And the benefit of that for those clients are that you get an absolutely tip-top copy of exactly what was said. Because most of my practice is advising employers, I would really rather sometimes that wasn't quite so apparent. Tribunals hate recordings and insist on them being transcribed. So there's a practical issue and a cost issue, because effectively every recording has to be transcribed, and that costs money and that costs time. But the bigger issue for me is that from an employer perspective, you need to be very confident that your managers are going to be able to conduct themselves during that meeting in a way which is not going to cause more problems than it raises. Because in a recording, things like pace, tone, what I would call back chat, noises off, all are very apparent. In a note, and bear in mind, we always say the notes are notes, they're not professional shorthand writers. It's a lot more bland, shall we say, and my experience is from an employer perspective, that is to the benefit. Having said that, there are some clients who are very sold on recording, and that happens as a matter of course. That's written into their procedure, and that is perfectly permissible. I'm just a bit nervous sometimes about those recordings, so it's more practical than legal.
Okay. Does the grievance procedure include non-executive directors and trustees, even if not specifically mentioned where an employee raises a complaint about their behaviour?
Well, the statutory right, of course, is limited to employees and indeed to workers. Non-exec directors are not employed. Trustees often may be employed, but generally speaking, I think best practice now is that you shouldn't be a trustee and be employed in that organisation or that charity. I would say that in the charities that I'm involved in, certainly our trustees, we have a separate complaints procedure. So if there is an issue, let's say, between myself and the chair of trustees, that's dealt with under a separate procedure, which includes elements of the grievance, but is distinct because I'm not an employee. And therefore, it would be inappropriate and confusing, I would say, to use the same procedure for both. Non-exec directors are a slightly different kettle of fish, but I think the clue is in the name. non-exec. So I think if they're so involved in the business that they're almost like hidden or quasi-employees, I think that's symptomatic of a broader issue. But generally speaking, I think there is this distinction between the statutory grievance for employees and workers and whatever happens to the rest.
Okay. So we've been asked, we've just announced a promotion for a manager, which comes into effect in a month. Although we've now started a grievance procedure with that manager following a number of complaints from other departments. Can we postpone the promotion if we've already confirmed it in writing?
That's a really good question. When you did the promotion, was it subject to any type of trial period? That would be the first thing to say. I think as well, even if you haven't made it subject to a trial period, even though the grievances are not concluded and may of course be found to be baseless, I think you're probably better. We've got various options. I think the first thing is to speak to the individual. The second is to introduce a retrospective trial period. Or the third is, even if they are nominally promoted, depending on the outcome of the grievance, they could of course be subject to disciplinary action.
Okay. Next question is, what can an employee do if their company does not have a formal grievance process?
Well, they're in luck really, because the definition I set out, which is in your section 1 particulars, will work. And or if you've got no formal, more advanced policy, if you like, you can always go back to the ACAS code of practice. But the policies are all pretty similar. So the stage 1 is the informal, and the stage 2 is a written complaint to the line manager and or the HR manager and or the line manager's manager, depending on the nature of the complaint. So you can use that implied process, but you probably ought to be reminding your employer that it appears that their section 1 particulars are deficient.
Okay. Next question is, do you recommend having a separate person hearing the grievance and another investigating it?
Generally, yes.
Okay, easy one, that one. Stage 4 mediation. It should be a stage 1 must-have and a stage 4 restorative measure. Is that correct?
I'm not quite sure what that question means. I mean, stage 1 is generally the informal. A stage 4 mediation, which is certainly raised in the ACAS code, I think is incredibly flexible. For me, we go right the way back. It is all about, this is supposed to be a resolution process. So understanding what that desired outcome is really critical. And it is quite interesting to me how often when I look at grievances, that question is not asked. And indeed, the griever is not pushed as to what their preferred outcome would be, because I think without that, I just don't see how you could ever get a resolution.
Okay, it's got quite a number of questions. I think we're going to answer 3 or 4 more of the questions, and then probably not going to have time to do all the rest. We've seen quite a number coming in now. How would you address a grievance where it's literally he said, she said?
Well, I think the he said, she said, we have to see if there is any other external collateral. So that might be another witness, that might be other emails. Often though, because it's not a disciplinary, if it's a he said, she said, both parties believe that they are in the right, for want of a better expression. So to me, we talked a bit about facilitating conversations. I think that's probably the route to go, because that would be my sort of recommendation, which is that we can't really take a view of if there's no other collateral evidence, we can't prefer A's view to B's view. What we've got to try and do is work together with them to reach an accommodation and to try and resolve the position, whatever that resolution happens to be. So I think I'd probably go down that route rather than a finding, if you like, of fact or belief. I think that just smack of disciplinary rather than grievance.
Okay. If a serial griever is found to be malice with unfair intent, do we need to take disciplinary action against them? And should this be in our policy?
Well, I would imagine that the way your policy is written is that you may have a great long you may say nothing about it at all in the grievance. And when you look at examples of misconduct and gross misconduct in your disciplinary, I suspect it would be written as a non-exhaustive list. So the fact that you haven't identified it per se in advance shouldn't be a burden. I think though that in that context, I certainly have known instances where clients have effectively moved down the disciplinary route because they felt it was malicious. I've also seen other clients who've moved down some of the substantial reason breakdown in trust and confidence route, which they felt was a more accurate reflection of the breakdown in relationship, and avoided some of these considerations about motivation and malice, etc. So I think either would be okay. I don't think you necessarily need to have it in your policy. Absolutely no harm having it in that policy as one of those non-exhaustive items, though.
Okay. Can the same managers who attend the informal meeting attend the formal meeting? I
think this really depends a bit on the size of the organisation you are and your own practice. I think ideally it will be a different manager, because how can you satisfy the employee's complaint or requirement for an investigation? You can't really be judge and jury of your own wrongdoing, can you? So I think ideally it would be a separate manager. I have seen clients where people have effectively had two goes at it. They've done the informal and the formal, and they've relied on a separate manager at the appeal or stage 3 stage, but that would be significantly suboptimal to me, and I would always prefer to have a separate independent manager, even if it's somebody on the same level as the first manager, or even sometimes perhaps slightly less, because I think that independence is so important.
Okay, last couple of questions. What are our options if the outcome the griever is looking for is unrealistic or unreasonable?
You have to go back to them and explain why it's unrealistic and unreasonable, and tell them what you are going to do.
Okay, and then last question. I've covered this, but is there any common employment legislation to fall back on in a grievance?
The only real legislation is one, obviously in the Employment Rights Act, Section 3, there has to be a reference to how they bring the grievance. The ACAS code does not have statutory force. However, in any grievance that you deal with, there should always be the person making the decision, if you like, or the person dealing with the grievance should at least have read the ACAS code, because if they ever go to tribunal, they'll certainly be asked if they've read it. And well, HR read it is not a good excuse. So it's a question of practice, as I say, and what you do. I think the key thing are these overriding principles. So one of them is about the right to a fair hearing. So that, to me, in this context, is understanding the grievance and responding to it. We've already talked about the need for independence, so that we're not the same person judging the same thing once or twice. And we also talk about general principles of reasonableness. So in this context, particularly, understanding what the grievance is, doing a thorough investigation, and conducting and finishing it in a reasonable timescale. Because I think it's this timescale point which could render a perfectly fair process unfair.
Okay. Well, thank you for your questions. Unfortunately, we don't have time to answer all of the questions that have come in. Thank you, Catherine, for what's been very, very informative. Of course, as I mentioned earlier on, it is quite a scary process for most people, and I think you get very quickly in depth into some very, very direct legal language, don't you? I think it can be confusing sometimes. So it's great to have clarification on all those matters.
Thank you. Well, I've really enjoyed it. And if anybody's got any questions, please do feel free to come back to me, via LinkedIn, and I'll do my best to try and answer them.
Great. There you go, guys. You can go directly to Catherine if you have any further questions. Just so you're aware, we do have another upcoming webinar in a series, is Managing Staff Holidays in an Ongoing Pandemic. That will be on the 7th of April at 10 a.m. I'm going to pop into the chat the link for that registration for that webinar. But thank you again for attending. It's been fantastic to have you with us. We will be sending out a follow-up email, and we will make the recordings available for this webinar. But thank you very much for joining, and have a fantastic day.